Welcome to Advocacy Exchange, Navigating Texas Injury Law.
Welcome back to Advocacy Exchange, Navigating Texas Injury Law with Paul and Larry Littleton. Larry Littleton is the founder of Littleton Law Firm and a seasoned trial attorney who's been representing injured Texans since 1976. Paul Littleton is the firm's Director of Business Development and Operations, helping guide strategy, communications, and how cases are developed from the start. I'm Lisa Mosby, your host, and today we're getting into what happens when a case moves from negotiation into a lawsuit and how that shift changes the direction of the case. Welcome, Larry. This is a big topic to talk about today, negotiation.
Oh, yeah. That's what you hope you can get it complete and do well.
And I know it's a skill set that you have mastered, so I'm looking forward to your insight. Larry, what tends to push a case out of negotiation and into a lawsuit?
Well, if the first issue may be a question of liability of the defendant, it may be a question of multiple defendants. It could be a question of multiple plaintiffs. You can have a situation where the medical is extremely complicated and it's difficult for adjusters to be able to understand it until it's all put into a permanent record. And that permanent record occurs when litigation occurs. Generally speaking, those are the main motivators that goes into litigation. But there are some other considerations. For example, the insurance company themselves. There are certain insurance companies that will pay very little, are notorious for it, and the only way they're going to pay what the case is worth is just file a lawsuit. And we know who they are. We tell the client who they are. And we let them know we're in the case. Get ready. Here we go again. We're going to file a lawsuit. But that's pretty rare. I'm not saying that happens very often. Most insurance companies, their adjuster is a hardworking individual. They get paid to get the job done, put the information into the computer to try to get something done. But sometimes the information is so complicated, sometimes the damage is so great that litigation is the only answer.
And once the decision is made to file a lawsuit, what changes about how the case moves forward?
Well, in our law firm, we make sure that the client understands what litigation is, why we're going into litigation, what to expect when litigation begins, what part they will play in that litigation, and in fact that it would be much more detailed. For example, in the normal standard questions that are asked in a litigation go back about 10 years. So that means all your health issues, all of the circumstances of prior accidents, all of those things that are detailed in your background will become evident. They'll be part of the discovery. So the client needs to know that well in advance, so it's not a surprise. The worst thing that a lawyer can ever happen to him is to have a client surprised. That's what we're supposed to prevent. Not guarantee outcomes, but eliminate surprise with information. So once we've got that explained to the client, and then we do the filing process and to get the lawsuit going. The main process as far as filing the lawsuit, getting the interrogatories done, the request for admissions, the discovery process, that's all done by lawyers and staff themselves. What the client participates in helping answer some of those questions, and later on, preparation for an actual deposition. That's where they will have to testify in front of usually a Zoom camera at their home and tell them about the accident.
Larry, how does the pace of a case shift after it enters litigation?
Well, the shifting occurs once you've notified the client what's going to happen, and in the filing of the lawsuit, and then getting service of the lawsuit. From the point of view of the client, everything slows down because the process has to be completed for each segment, from the filing of the lawsuit to the actual service of citation, the answer of the lawsuit, the discovery and disclosures required to have to be filed, along with the preliminary information that we're requesting from them also, and they're requesting information from us. That process takes about 3 months to complete. The deposition is something that usually occurs about 4 months, 4 to 6 months, depending on who it is. So for a 6-month period of time, not much is happening at all other than contacts from our office saying, "How are you doing? What's going on?" Because sometimes when some of our clients are having got huge, devastating injuries, they've got injuries that are continuing. We need to be continually updated on the doctor appointments and what they're saying and what kind of problems they're having. So there's conversation going on during this period of time for the discovery section, but it's not a whole lot of involvement for the client until we get close to the deposition.
And then what new phases or steps come into play once a lawsuit has been filed?
And usually the steps are once we've got the lawsuit filed and go through the discovery process, they call it. That's where they send us questions and we send them questions. The client comes in and to answer those questions. Most of the questions we already have the answers to because we've developed a claim, but there are some questions that we have to go into detail. Once that exchange is completed, then we move on to the deposition stage. The deposition stage is much more involved for the client because we will actually go through the various kinds of questions that they will ask. The purpose is not to tell the client what to say, but to make sure they understand what the question they're going to be asked so they're not be surprised by the question. You can have questions the defense counsel can say and ask questions about something that happened 10 years ago, about an auto accident, which shows up on their report that the client was at fault, when in truth and reality, they were not at fault. It could be a situation about extent of injuries. We've had cases in when a police officer had indicated that our client seemed to have a head injury and that they seemed unable to comprehend what was going on for a few minutes. Well, then the insurance company comes up and says, "Yes, but your client was treated with high blood pressure and was diabetic. We need to find out if he was under all those circumstances were under control." So if those become issues, we need to make sure the client knows, hey, they're going to ask you about it. You don't want a deposition to come down. The defense counsel says, "Isn't it true you have high blood pressure?" "Yes." "What's that got to do with this case?" "That's not anything to do with my case." You prepared the client to let them know they're going to ask for high blood pressure. The question is, were you taking medication and under control? "Yes, I was." That's the answer. Okay, so after the deposition stage is completed, by that time, we already have what we call a docket control order. The docket control order sets down all the sequences of events, when the discovery has to be completed, when the depositions have to be completed, when the mediation should be set or completed, and then there will be the last date will be the trial setting. So all of these things are kind of like an index as to what's going to happen next. And we explain these things to the client when it's necessary for them to understand what the next sequence is. But generally speaking, from their point of view, it's kind of slow when it first starts. It kind of speeds up with the deposition. And then when the moves towards mediation, then it can starts getting really focused because that's when we want to make sure prior to the mediation, we have all the medical records. We know all the treatment. There hasn't been another doctor brought in, or there's not something additional about lost wages, or their employment status is the same. All the factors that will be discussed at a mediation, we want to make sure that we have the most current information in order to be able to present the case in such a way to get as close as we possibly can to full recovery.
So let me see if I understand this correctly. When the court gets involved, that starts to influence the pace of it, the timing of it. There's different steps that have to follow and happen in a certain order. Would that be correct?
Yes, it's at different points. For example, the discovery stages has little to do. Sometimes there is an issue of discovery and has to be taken for the court to get a proper answer. But that is just setting up a motion and having a hearing and having the judge rule on it. That can happen at times. But as far as the progress of the case, the things that move a case quicker through the normal course of the docket control order is the completion of all depositions and then an agreement to do mediation. In Texas, most of the district judges require mediation. Why? Because mediation on 99% of the time reach a settlement, and that takes their off their docket, and they don't have to worry about trying the case. So it's a win-win for everybody.
Yeah, for sure. Uh, I always come back to this. Do you have a situation that we can walk through where filing a lawsuit significantly changed how a case played out?
Oh yes, you can have. We've got a case that is very difficult to understand because it was involving an 18-wheeler. The 18-wheeler weaved back and forth in traffic for about 6 miles and had multiple accidents. Our client was on the tail end of it, the last accident involving in which our vehicle was hit from the rear corner and shot across and hit another vehicle. And then that vehicle went back and hit the 18-wheeler again, all moving in the same direction. It turns out that the 18-wheeler had had an accident much earlier down the freeway and decided to evade the accident scene and leave. In the process of leaving, he ended up going in a wrong way on a street, resulting in multiple collisions until he made a right-hand turn onto a circle intersection where he ends up colliding with my client. All was said and done, the insurance company couldn't figure out who was going to file what or figure out who was the damages. There's so many plaintiffs. As it turns out, through litigation, through mapping out the sequence of events, being able to make sure that each of the events were separate accidents. Once you had that agreement, once that was completed, then you're limiting it to the number of plaintiffs for that individual incident. All of that could not have occurred without the discovery process to allow for those issues to be discussed and completed of record. Not what people are going to say, what they actually said. Okay? Once we had that completed with it, then it boiled down to the plaintiffs that had damages and their injuries. One of the plaintiffs had a very minor injury and settled out of the case very quickly. We went to the mediation. The mediation was successful in being able to give full recovery because we had taken out those plaintiff cases that were small, not much damages involved, and focused on the serious injuries, which included our client. So the result was that the litigation process allowed for each of the issues to be emphasized, to be fully discovered, to be able to verify what is real and not real. And then those considerations were able to have the damages properly assessed for each plaintiff.
Wow, I can't imagine the time frames on all of those moving parts. Uh, I want to come back to litigation instead of negotiation. What trade offs come with moving a case into litigation instead of continuing with negotiation?
Well, if you are negotiating with a claims representative and they have reached a point to where they think this is the X amount of value and we're not going to pay anymore, you don't like it, Larry, file a lawsuit. And when they reach that point, after I've discussed it with the client, what their alternatives are, what the possibilities are involved with it, and if the client says that's not sufficient, I don't want to accept that circumstance, then we notify the insurance company we're going to move on it. But before we do that, we make sure the client understands what the situation is for the expenses, what the situation is for attorney fees and cost, expert testimony, demonstrative evidence, all the things that we may need in litigation. Sometimes it's not an issue at all. It may be a complete denial, or it is a payment of on 50% of the value, for example. Sometimes it's based on, like I said before, who the insurance company is. Some insurance companies are not going to pay full value until you file a lawsuit and you've got them down there ready for a trial. So those all influence, decisions involved with it. The last part of it is that the person you're dealing with in a litigation is usually a defense counsel. Defense counsel can give a proper assessment of the evidence and the issues and present it to the adjuster. The adjuster, most of the time, is a litigation adjuster. In other words, you've moved from claims adjuster to litigation adjuster. And that usually helps move cases along, particularly when the evidence that was in dispute had been taken care of and given to the other side, demonstrated, depositions, all the things necessary to prove that fact are already there when they were not there in the claims situation.
Larry, here's the wrap up for today. For someone trying to understand where their case might be headed, what should they know about how that decision gets made?
Well, a client should be fully informed, period. Okay, whether it's a claim, transition to litigation, or if it's quickly into litigation. Usually, when I do the interview, most of the time I can tell when a case is going to go to a lawsuit or not because of who the insurance company is, the initial contact, or why they're doing what they're denying the case for, whatever's involved, and also the injuries. For example, if we've got a situation where there's partial liability on the part of the client, but the client has devastating injuries, hospital bills well over $100,000, that kind of thing, then the damages and the issues can take care of themselves because of the fact that the policy may be only $30,000, or it may be a $50,000 policy, and the value of the case is over $1 million. So that may affect the issue involved. But the point is, what the lawyer is required to do in Texas is to make sure that that client is fully informed. They know what to expect. They know what the next steps are, and to make sure that everything is completed. Yes, there's unknowns. We don't know all the answers, and that's what we tell them. The best way we can make a full recovery is you're going to have to file a lawsuit, and I need to make sure that you're committed to doing that. Are you with me? Are we ready to go? And that's when we get an answer.
There we go. Thank you, Larry. That's it for today's episode of Advocacy Exchange, Navigating Texas Injury Law. If you've been injured and have questions about what happens when a case moves into litigation, the team at Littleton Law Firm is here to help you understand your options. Visit littletonlawfirm.com to learn more. Thank you so much for listening. Don't forget to like, subscribe, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.